Good morning, friends. Today we are going to have the 14th lecture, which is about the activity level under different rules. So far, what we have studied is actually the precaution level under the total rule. That is how that precaution is making the behavior of different parties in a tortious case, such as the plaintiff's precaution as well as the defendant's precaution. So, what we are going to discuss today is the activity level under this rule, the rules which we have already studied, that is the strict liability rule, negligence rule, simple we had already studied the strict liability rule, strict liability rule and the no liability rule, but we haven't actually talked about what would happen the level under negligence rule, different negligence rule. The four main negligence rules, such as simple negligence, comparative negligence, and negligence with the difference of contributive negligence, and etc. So let us talk about the simple negligence. So injurers is only liable if he was negligent. So this is what we had talked about. An injurer who is liable if and only if he or she is actually negligent. So which leads to injurer to take efficient precaution. So from the injurer's point of view, it is always better to take an efficient level of care, because that level of care only makes the person scot-free. So injurer expect to not to be liable for any accident that do occur in the course of action. So normally, therefore, it is always advisable to take that level of precaution. But so injurer ignores cost of accidents when deciding on activity level. Therefore, this is what is actually the culmination of what is actually you talk about only precaution. So if I am concerned about precaution, then I must take a necessary precaution. Once I take necessary precaution, then it never comes to my mind that I have to actually worry about the activity anymore, because now the activity levels issues are being internalized as far as the injurer is concerned. So injurer drives carefully but still drives too much. So victim bears residual risk. Now if you drive carefully, at the same time you drive too much, then the probability of getting you into an accident will increase. Why? Because the level of activity had gone too much. So that will actually bring you your probability of getting accident. So then victim bears residual risk, as we have already said in the simple negligence or negligence. If the other person, the injurer, is sufficiently been taken care, then the residual cost is going to befall on the person who is actually victim. The victim bikes carefully and bikes efficient amount. All right. So what is actually this is the case. So from the victim's point of view, victim also takes a level of care, but at the same time, the activity level of the victim is also very efficient. Why? Because the residual risk is going to be fall upon the victim. Therefore, victims are always take a necessary step to avoid such a high level of probability. Therefore, their activity level being always checked, but not necessarily the injurers in that sense. So, what is going to be the case? The injurer's activity level too high in the matrix, and the victim's activity level is efficient. So let us discuss about the other two rules, which is negligence with the defense of contributory negligence and comparative negligence. So what is going to happen in this two rule? Either the rule efficient precaution with both parties, as we have already said. So either rule, if neither party was negligent nor injured, does not of damage. So in both the case, that is in defense negligence with the defense of contributory negligence, and comparative negligence. In both the case, neither party was negligent in that sense. Injurer, if neither party was negligent, injurer does not owe damage in that sense. So victim is residual risk bearer in this case, very much a risk bearer. Payoff of an accident has to be bear in this case by completely by the victim themselves, him or herself. Therefore, what happens is very simple, that the activity level of the mm, victim would be also being checked. So victim weigh cost of accident against benefit of activity, takes efficient level of activity, and injurer ignores cost of accident, take inefficiently high level of activity. Now that is actually going to make our matrix in the following way, that is negligence with the defense of contributory negligence, the injurer's activity is too high and victim's activity is efficient, as well as comparative negligence, injurer's activity too high, victim's activity is efficient. So in the case of strict liability with the defense of contributory negligence, if victim is not negligent, not if victim is not negligent, injurer is liable. That means if I took some care, non negligent, then the injurer is actually strictly liable. So leads to efficient precaution with both. So injurer is liable. And injurer is residual risk where therefore injurer weigh cost of accident against benefit of activity, takes efficient activity level. So victim ignores cost of accidents, takes inefficient high level of activity. So what is the final matrix point? That is strict liability, defense of contributory negligence, injurer's activity level is efficient, and victim's activity is too high. An easier perhaps way to understand all of this is, see, when take precaution only to avoid liability. So this is why, but the result is too high level of activity. So if you take precaution in, for avoiding liability, but at the same time what you spill over is actually your activity level is increasing quite a high. So precaution is efficient, but activity level is actually too high. Again, to reduce accidents, since he bears their cost, this efficiency is also important. That is to reduce accident, since he bears their cost, precaution and activity level both efficient in that sense. With each negligence rule, one party can avoid liability by taking efficient precaution. Leads no efficient precaution in that sense. No, but inefficient activity level, otherwise other party is the residual risk bearer. Even when he or she takes precaution, he is or she is still liable. Leads to efficient precaution and also efficient activity level. Why should bear residual risk? This is the question. Why people should bear the residual? One way to answer this is, that is one way to answer is to ask whose activity level has greater impact on efficiency. Now put the incentive where it does the most good. Put the incentive, the efficient rule depends on which choice have greater impact or greatest impact. If only injurious choice, precaution plus activity matter, then strict liability is better rule. If bilateral precautions, then negligence rules are better. Now, which negligence rule depends whose activity level is more important. At the beginning, in the year 13th lecture, we said already that in the not only in the 12th lecture and the 13th lecture we mentioned about it, and in the 12th we detailed about the possibility of the political economy intervention in the lecture, and we said that parting itself, the third party's position itself is going to be very much important, because this has been assigned by the third party. Whichever rule which we talk about, like a liability rule or negligence rule, within the liability rule, whether it is strict liability or the negligence rule, like the strict liability, the defense of contributory negligence, uh, then or the other negligence like comparative simple and negligence in the defense of contributory negligence case, all this is in fact gives a kind of hint that the third party's position on which side they are. That is also very much important, but normally in economics we don't talk about this parting position of the third party, because we assume that that portion is being assumed neutral. So if you assume that neutral, then this problem may not be the concern of an economist. Otherwise, it is, because even economists talk about this third party institution because of the intervention and influence of the third party. Otherwise, there is no point of talking about this law in economics per se. So, which negligence rule depends, therefore, whose activity level is more important for the government, whether the government is parting with the producer or the consumer, etc., under the product liability case. So, Friedman citing Posner, that is, this is why very dangerous activity is often covered by strict liability. So even in the among economists, people are very much having consensus that is the efficient bearer of the risk has to have the liability, and therefore the product liability cases, it is always given a stricter liability to the producer. So but most of the countries this is not the case, but in the United States they are trying to argue for it, especially the product liability case. So blasting with dynamite, keeping a lion as a pet, etc., are product liability. In that sense, you even with the proper precautions, still very dangerous. So injurer activity level is important, because you say that okay, I can have a gun, for example. Having a gun is in the United States is you are, it's a matter of your private right, because you value your life, therefore you can keep your gun to guard that. So but the problem is that if you cause the by accident also, then you are liable. You have to, you are answerable in that sense. So keeping a lion as a pet also, it's a wild animal, and most of the time it is always dangerous to keep, and if anything happens, then you have to pay. So therefore the in this case, the efficient bearer of the risk is always the lion holder, or the person who keep the pet, or the person who is handling this dynamite or material. So Friedman said that the activity is just unobservable precaution. Okay, so liability, again within the strict liability, sorry, the negligence rule is strict liability with the contributor. Negligence case is more suitable when it's when the unobservable precaution, that matter is being considered. So activity is just another type of precaution, therefore, but type where court can't determine efficient level. That is why we said we can only say too high, too low, or very high, very low, or whatever. That itself is actually a qualification which we attribute. What is too high, what is too low, etc. Again, you can keep arguing for. Therefore, code can tell inefficient for me to drive at night with the headlights off. Can't tell how many miles it's efficient for me to drive. Okay. Determinations of the negligence can only be based on observable precaution, not unobservable, therefore. So negligence rule leads to efficient level of observable precaution by both parties. Simple negligence lead only to efficient observable precaution by insurer, but inefficient precaution by victim as well. Strict liability lead to efficient observable and unobservable precaution by insurer. but no precaution by victim. So this is the case where Stephen Chauvel had already pointed out, and all the tortious case, by the way, the reference book is the best book is actually Stephen Chauvel's accident book, that is on economic analysis for accident law. So and note that there are many articles which was written, dozens of articles were written by Stephen Chauvel on these issues. So strict liability versus negligence, for example, one paper talks about that is focus on injury precaution and activity level, which we had already derived in all our lecture. But this is specifically speaks about this thing, that is compares strict liability to negligence rule accident between strangers. We have been doing under a negligence rule, all that an injurer has to do is to avoid the possibility of liabilities, to make sure to exercise due care if he engages in his activity. Consequently, he will not be motivated to consider the effect on accident losses of his choice of whether to engage in his activity, or more generally of the level at which to engage in his activity. He will choose his level of activity in accordance only with the personal benefits so derived. But surely an increase in his level of activity will typically raise expected accident losses. Thus, he will be led to choose too high a level of activity, whereas under strict liability, because an injurer must pay for losses whenever he or she involved in an accident, he or she will be induced to consider the effect on accident losses of both his level of care and his level of activity. His decision will therefore be efficient. Because drivers will be liable for losses sustained by pedestrian, they will decide not only to exercise due care in driving, but also to drive only when the utility gain from it outweighs expected liability payoff to the pedestrian. So this is exactly what we had already concluded. So therefore, in the case, it is quite clear that in the strict simple negligence with strict liability, injurious precaution is efficient, whereas in the simple negligence, too high is the precaution, whereas in strict liability it is efficient in that sense. So injury is in a competitive business, but not with the victim. Victim is not an injurer's customer, but a stranger in that sense. So therefore, it's always the injurer is the efficient bearer of the risk in most cases, not actually the stranger, because you can't simply say that this is always the stranger's case. So example, taxi drivers, that is provide services to their passenger, risk hitting other pedestrians. Victims are not their own customers, and Stephen Chauvel is imperfect competition, that is price is equal to marginal cost of production, where sale is equal to number of passengers who demand rides at the price. Strict liability, where the taxi driver pay for accident, the set is x is equal to x star to minimize private cost. Perfect competition imply most of the remaining accident is built into price. Taxi passengers face price, that include cost of accident. Passengers internalize risk of accident, demanding efficient number of rides. Whereas negligence rule, taxi drivers still take efficient precaution to avoid liability, but since drivers don't bear residual risk, cost of accident not built into price. Passengers face prices that are too low, lower than social cost of taxi ride. Demand for taxi rides inefficiently high in that context. Therefore, you have this case, that is an accident between business, where simple negligence is efficient, whereas strict liability is efficient on the other things in that sense. So, a final case of accident between business and their own customer, a restaurant taking precaution to reduce risk of food poisoning. So, how accurately do customer perceive in this case risk? Normally not. Customer can accurately judge risk of each restaurant. The customer can accurately judge average level risk, but not difference across restaurant. Customer is ignorant of risk. So in the second and third case is most likely, and sellers bears cost of accident, efficient precaution, and sellers bear residual risk. Expected cost of accident is built into the price. So even if customers don't perceive risk, price leads them to make efficient choice. Prices of shellfish, for example, is equal cost of shellfish by expected cost of food poisoning. So even if I don't know that, I buy shellfish when benefit which is greater than prices, so I am forced to choose efficiently. So restaurants take efficient precaution to avoid liability, but since they avoid liability, cost of accident not built into prices as we thought of and talked of. If customers perceived risk correctly, no problem. That is a way benefit of meal versus price plus the expected pain due to food poisoning. That demand efficient number of meal is also depend on that. That is, but if customer don't perceive risk, they will be demanding inefficiently many dangerous meals. So there is also a case. So if we talk about no liability, if customers correctly judges risk, restaurant takes efficient precaution to attract customers, and customers demand efficient number of meals. If customers can only judge average level of risk, restaurants take no precaution in that context. But customer know this demand efficient low number of meals. So if customers are obvious to or oblivious to risk and the restaurant take no precaution, cost of food poisoning not built into prices, and customers demand inefficiently high number of meals. Therefore, so you have all this possibilities which have been derived from this book. So in the Stephen Shavel's finding and his analysis, in fact, given a very beautiful insight on this problem. So strict liability, and in the beginning we said that why there are certain countries had this sort of a pattern that they were used to have strict liability, then they moved towards negligence, and again they moved to strict liability, and again they moved to negligence, etc. So this is also trying to hint as the point we began with, as well as the in the beginning of this lecture we mentioned about the political economy, or the siding with which party you are. Sorry, which party you are siding with is also a matter of concern under this analysis, and that is going to have some sort of a positive effect in the social benefit or cost which we are going to have. With this, I would like to conclude the lecture today, and thanks for watching as well as listening the lecture. Thanks once again, and have a good day all of you. Thanks.